about what have been the challenges around being able to achieve a mechanism to operationalize a not more than two-thirds gender principle. Since the promulgation of the Constitution of Kenya 2010, we've seen several attempts, but it's yet to pass. There's yet another bill before Parliament, the Constitution of Kenya Amendment Bill 2018. It's commonly referred to as the Aden Duale Bill because he is the mover. But already a lot of critics saying that it has got many holes in it and should not stand as it is. We'll get to that. But an important one to note, because I want us to listen to President Uhuru Kenyatta calling on Parliament to pass this bill. He's done that before when there have been other attempts and bills before Parliament. Let's first listen to what he had to say, and then I'll introduce my guest to you and we start the conversation this evening.
Najua wengine wanasema hii sijui itaongeza gharama itafanya namna hii. Lakini ule mswada ulikuwa hapo awali umebadilishwa sasa. Na vile viti ambavyo tumeweka zimepunguka kulingana sasa na vile katiba yetu imetueleza. Na ningewasihi kwa heshima ndio tuhakikishe ya kwamba kama taifa la Kenya we have heeded to what our constitution has said. Pitisheni huo mswada. Na ndio yale ambaye tunatenda inalingana na katiba yetu.
So an important statement the president makes there, yale ambayo tunatenda inalingana na katiba yetu, but some have called him out. And I wish we'd just put up that picture of the cabinet, his cabinet we had earlier on the introduction, because this law and piece of legislation, or rather requirement in the Constitution, says not more than two-thirds of either gender in appointive and elective positions. So the president appoints members of the cabinet, and this is his cabinet in that picture. And the cabinet on definition is not just the CSs, it includes the president, the deputy president, and the attorney general. So that as it stands, we have 24 as cabinet members, okay? Out of those, just 6 women. So 2 short of that 1/3. So as the president calls on Parliament to pass this legislation, where he has power to do in appointing, he has yet to do. And remember last year, there was a ruling indicating that come the 2017 election, after that the government to be formed, they must be sensitive to ensuring this rule is applied, or at least this principle is met. So that's one. And of course, there was also a ruling directed at Parliament that expired last year, I believe it was March, as well, asking the 11th Parliament to ensure there's a mechanism put in place. So just to put into context, as we hear those political sentiments and a lot of the rhetoric, rhetoric is not political will, some will argue. My guest this evening, I have on my immediate right, Honorable Gladwell Tungo. She's the woman representative, Baringo County. In the middle, we have Marilyn Kamuru. She is an expert on gender principle matters. She's written extensively on this. In fact, she will be starting us off in our conversation tonight, just helping us understand where we've come from and where we are. But before that, also with us tonight is Honorable Samson Cherargei. He's a Nandi County Senator. He's also the chairperson of the Justice and Legal Affairs Committee in the Senate. Thank you all for being with us. So I'll begin with you, Ms. Kamuru, because it's happening now. Many have had this conversation before, but you have been part of efforts, not only writing about this matter, but efforts to hold power to account and really question whether it's a suit against the president on what he's doing, but also on should Parliament be dissolved. Talk to us about where we've come from and where we are.
Okay, thank you very much for having me. So this journey obviously began in 2010, and I think that's very important because part of what we're hearing is extremely dishonest from people about, you know, Kenyan people don't really support this principle. The 2010 Constitution was a complete break with where Kenya had been in the past. And so with the 2010 Constitution, some of the things we adopted were like Article 10, which talks about the principles and the values that we have. And one of them is equality. Right?
Yeah.
So Article 27, which is the Bill of Rights, which talks about the equality, the right of equality for both men and women in all spheres, social, economic, and political. That's where we have the provision on not more than two-thirds. So in 2010, we passed the Constitution, and we waited, and you know, in retrospect, this was obviously a mistake. We should have had an election right away to make sure that the people who got into office had the impetus to implement the Constitution.
Right.
But we had an election in 2013. Before that, the Attorney General sought the opinion of the Supreme Court of Kenya because the Attorney General averred to, and this is the position of the Office of the Attorney General, because that's not a person. The position of the Office of the Attorney General was there would be a constitutional crisis if Parliament was not constituted as required in the Constitution. And there was no mechanism for Parliament, so for the National Assembly and for the Senate. There were mechanisms for the county assemblies. And the Supreme Court said, in a majority opinion, that Parliament had until August 27th of 2015 to implement this legislation. The Chief Justice at the time, Dr. Willy Mutunga, dissented, and he said in his opinion, Parliament should be compliant from the very first election. So the Parliament had until 2015. However, even in 2015, the very first bill that was introduced as a result of a court case that was brought by Crew and Crown Trust. And that court case essentially sued the Attorney General and the Constitution of the Committee on the Implementation of the Constitution, CIC. And they basically said, you know, under the provisions of the Constitution, Parliament was supposed to have enacted this bill, and they hadn't introduced a bill. So even the very first Duale bill that was introduced by court order. So the court mandated that. And so the bill was introduced and it failed. There were subsequent attempts, and those have also, I actually would say subsequent attempts have not been failures. They've been refusals by Parliament, because Parliament has been under direct court order. The Constitution was silent about the mechanism, but the Constitution is very clear about who has the power to interpret law. And in Kenya, the only body that has legal power to interpret law are judges, is the judiciary. So Parliament doesn't get to interpret the Constitution.
Correct.
They enact legislation. So once it was interpreted by the Supreme Court, and then again interpreted by a High Court petition 371 of 2016, and that's the Mativo judgment that gave Parliament 60 days, the 11th Parliament 60 days, and that order is valid. There was no stay issued on that order, so that's a valid court judgment. So essentially today what we have is that the 12th Parliament exists. First of all, the 12th Parliament itself is not constitutionally compliant, but that the 12th Parliament has an obligation to enact legislation that comes both from the Constitution, but from court judgments. So it's a misnomer to speak about this as a gender bill, because it's actually a constitutional compliance bill.
Yeah, it's not a favor, it's not, let's try figure this out. The law is clear, it's just make it work.
It's not just the law is clear. I mean, our Constitution is actually very clear that rights belong to the citizens, they don't belong to the state. So the Republic of Kenya doesn't give any one of us rights.
Okay.
Those are rights that we have by virtue of being human beings, by virtue of being people.
All right.
So we talk about Article 81B, but those are electoral principles. Article 27 is the Bill of Rights, and that's where the equality, the right to equality rests.
Comes in.
Yeah.
Honorable Tungo, let me bring this to you. Being an elected member sitting in there, when you hear the various angles of debate, and perhaps we'll be able to canvass some of them, but what do you make of just that background we have from where we've come from, and that a lot of this appears to be forced down the throat of a parliament that appears not ready to do what it should be doing, and also the president not meeting this at his own level where he can appoint?
Yeah, I want to pick it from there and say, for sure, this is the first time I'm sitting in Parliament, and when I reached there, when the 2-that gender rule came, I noticed with a lot of fear that people are not actually ready to pass this bill, and that the women of this Parliament, for the 8 years that have passed, they have really tried to make this bill pass. They have been saying they've been persuading the men, our colleagues, to really assist them in passing the bill. But again, I'm wondering, when I asked them, who actually said that gender is women? Because there is a misnomer. People are perceiving gender to be women. But the truth remains, gender is not women. Gender is just to say who somebody is by right of birth. Is the sex. It is not women. So for a long time, people are mistaking the gender bill to be a women bill. But then it is a constitutional requirement that people should take it up and know that we are working and we are not respecting the constitution that we ourselves passed 2010. Because you see, we have implemented almost everything, let's say virtually everything, but that is only the part that we are becoming very hard in implementing.
Why do you think that is the case? Why do you think it's become a sticky area?
The issue is, okay, yes, people are perceiving it to be women issue because we are the ones whom we are saying we are few. If men were fewer, they would have been the other way around. But again, there's the conversations I get in the corridors of parliament is there are a lot of fears. The fear that people have, okay, the male counterpart feel that women are really favored. They feel we are favored. They wonder why we should not be given a ground that we can compete so that we can be parliament. And the other bit that they are talking about seriously is the process of nomination. The process of nomination is the one which has made people to be a bit skeptical in passing this bill, because what they are saying is that there are no merits. The process is not clear. It is not known who is going to be nominated and why. So there are no merits. You just fight, because for sure, I have also seen the people who really fight in the political arena during elections, they work very hard for the party, they do everything they can, they exhaust their money, they waste their time. But when time for election comes, just somebody from, many of them from nowhere, they are given positions, and people are like, why? So the merits should be put.
And we'll talk a little bit more about this specific bill that's now before Parliament. But Honorable Cherargei, I want to first get your thoughts on why you think it's been so difficult so far. All these years that there have been several proposals brought, but a lot of what we hear from members always with each proposal is a conflict and a divide around no, and yes, there are those who feel it's tokenism, women are being favored, they're being given positions for free, the wage bill question, all those issues come up. But why has it stalled in your view, truly, this far?
Thank you, Sophia, for having me tonight. I think the reason it has stalled, you know, this constitution is an activism constitution and is of ambitious. It has never been seen anywhere in the world. We are working in a very new path that is less trodden, and I believe there are so many reasons as to why it has stalled, as my colleagues have tried to elaborate. What I want to agree is that in this country, we need to create a level playing ground for a competitive in politics. And I'm happy you did, in fact, in your introduction, you talk about even as we question Parliament, have we done the audit of other organs, both state and non-state organs? Because even as we talk, even in executive level, both at county governments and even a national government, no one is talking about the audit, whether the gender parity has been achieved at that level. And I think from the mood of the House, even at now, or even before, in 2015 and even in now 2018, from the mood of the House of the National Assembly, I have a strong feeling that this gender bill will not see any day of light. But if it comes to Senate, I'll be the first person to oppose it. But if the parliamentary group will be called where the highest decisions will be made, some of us will cautiously accept, but with amendments. And that is why I agree with my colleagues that gender is not about women. And therefore, if we have the support of men, we should relook at the entire bill in terms of the nerve center of the bill. But I agree that the reason it have been stalled is because of the fear, maybe the women, the male counterpart fear. But I think also we do not fear. I want to demystify. We want to teach the women the hardball, as in they should be taught to fight for this. Remember, I have an argument for that. In 2013, there was many complaints in this country that why are youth not being elected? Why are youth people living with disability not being elected? But when young people realize you cannot be babysitted and be given these nominations, that's why as we talk, the National Assembly and the Senate, a half of the elected legislators, both at the county assemblies and even at the National Parliament, are youthful. It is because they realize you have to fight for these things. But if we make women that if you run for an election like Mheshimiwa Gladwell Tungo, if you run for an election and lose, there is an option of nomination. Then we will not be fair to them, and we'll be creating what we call negotiated democracy, whereby we are punishing voters for voting for a man, which will be unfair, because anywhere the universal suffrage under United Nations Declaration on Human Rights is that you are given the freedom of choice. It is like we will be now forcing Kenyans that you must vote for a woman so that we risk
so when
not
political
nominating
parties issue direct
Finally,
nominations, and they're not forcing Kenyans?
No, it's
and
of
we
course,
see a lot of the
and that is why the
parties
problem
have largely failed Kenyans on this gender question, because a lot of the direct tickets, or even those the big parties will back, and we know a lot of our politics is deeply entrenched in tribalism, will be men. We will rarely see big parties say, for example, in Nairobi, this woman is going to be our candidate for governor.
But historically, what is shocking, this issue of affirmative, let me go back a slight bit. In 2007, I think, to 2013, there were women who were elected as members of parliament at that point in time. As we transit to 2017, we have 3 elected women governors. We have 3 elected women senators, and they come from big parties. So it is a wrong notion, and that is why that has been the weakest argument by women leaders or some section who support the agenda of women by saying the political parties will not give her space. I know she is of course I don't know the strength of KANU, but KANU used to be a very big party, and therefore I don't know whether she was denied ticket for simply because she did not come from where. And finally, on the issue of nomination, I agree with them that there is no clear issue, because sometimes you walk into a county assembly or even national parliament and you sometimes wonder, where did these people who are being nominated come from? And I want to agree with what Mheshimiwa Didmus Barasa said. These are flower girls and page boys, because in my own opinion, somebody who should be nominated somebody who should bring special skill, somebody who should be of higher pedigree, just so like House of Lords in Britain.
And that's why it's important to have a criteria of the nomination. And let's bring Ms. Kamaru. I'll come back to you, sir. And let's talk about the legal question, because what then would be concerning somebody watching is if there have been court orders. Parliament has been told to do 1, 2, 3 by this period of time. That time expires. Here we are. The presidency, because it's not the president as Uhuru Kenyatta, he so happened to be the president elected in 2017. Again, not complying. So how do we, if we're not, the rule of law is not prevailing, what are we talking about?
Which is why I think it's really important that people understand that this is not a bill that's about gender. This bill is about whether Parliament and the executive are exempt from compliance with the Constitution of Kenya 2010. Because when you hear, the Honorable Member of Parliament saying that he will vote against a bill that he is required by court order to vote for, you can change that bill. There is no requirement that this bill, once they pass it to comply, they cannot then pass something else that would make sense. But what they want is the time to play around. And I think men are being dishonest. I mean, have the courage to say that you do not believe that women belong in power. Have the courage to say that. And the reason they cannot have the courage to say that is because their female voters will reject them. So what they're doing is they're giving us these nuanced arguments around, women and these nominations are a problem. Political parties do nominations, and the Speaker ruled on the floor. And he said, you know what? Subsidiary legislation, you can bring in subsidiary legislation on the criteria for nominees. So that's not a reason to vote against the bill. It's just like saying, you know what? We can't vote for devolution because it's not perfect. We will not allocate funds for X bill because it's not perfect. There will never be a bill that is so perfect that the men of Kenya in Parliament will accept it. It is not a method question.
So is this patriarchy?
It's not patriarchy, and it is not political will. This is lawlessness. This is lawlessness. Parliament is an institution that is a creation of the Constitution. So Parliament's powers, and I'm sure that my fellow Akili will agree, that the powers of Parliament are limited to actions in accordance with the Constitution. Anything that Parliament seeks to do, whether by omission or commission, that is in violation of the Constitution, is illegal and invalid, according to Article 3. So we're not talking about options. We're actually talking about whether Parliament believes it is exempt from the Constitution, in which case it means that we don't have the sovereign will of the people. That the Kenyan people no longer are in control of what's happening in government.
Right. I want us to take a short break. When we return, we'll get a rebuttal because I see you raising your finger. You want to say something. And of course, we'll also hear from Honorable Tungo. Stay with us here on Checkpoint. Also, would love to hear from you. What do you make of this conversation? You followed what the politicians are saying. But it's all about Wanjiku. What do you think? Tell us. Sophia Onuna is my handle. The hashtag is Checkpoint. Stay with us.
This is KTN News.